See, amendments to criminal laws, Indian Evidence Act, Criminal Procedure Code, IPC, can be maybe done by the state, the government. See, following proper procedure. And normally the amendments would be carried out by the Law Commission. See, 1973 Criminal Procedure Code was amended after due deliberation by the Law Commission, 41st Law Commission of India. So now here, total numbers are changed. The section numbers, it's all numbers, whether it's a Evidence Act or Criminal Procedure Code or Evidence Act. It's all numbers. We remember by numbers. So each section is given a number. That number is very, very significant. But all of a sudden, rebooting, revamping, replacing the time-tested testament for the last 150 years and more, all of a sudden completely revamped, replaced, numbers are changed in the name of Indianization of the criminal judicial system. This is unacceptable. This number change is unacceptable because every lawyer who practices from Kashmir to Kanyakumari has their own library. The library, criminal library, is the numbers only, section numbers only. Now the numbers are completely rebooted. So we have to remember. It's not so easy. See, we studied law. We studied law for 3 years or 5 years. Then we started practicing for several years. Everything is memorized. And any time anyone asks for the section, we can immediately quote. So now we have to remember. And what is the purpose? Whether it serves any purpose is the issue before us. See, this amendment is in violation of Article 348, which says that all law material shall be in English. The names also should be in English. See, what is this language? What is this language? Bharatiya, Sakshya, Adhiniyam. What language is this? Is it Telugu, Kannada, Malayalam? Whether it is Punjab, Sindh, Gujarat, Maratha, Dravida, Utkala, Vanga, none of this language. Bharatiya, Sakshya, Adhiniyam. Bharatiya, Suraksha, Nagarika, Sanhita. Bharatiya, Nyaya, Sanhita. See, IPC, it is an Indian Penal Code. It's a Nyaya means justice. Where is the justice in Indian Penal Code? It is a penal code. It is a penal code for punishment. What is the necessity to use the language Nyaya? Where is Nyaya? Where is justice? Penal code is for punishment. Why it is named as Nyaya? Then Bharatiya, Sakshya, Adhiniyam. Which language is this? Is it Telugu? Is it Malayalam? Which language is that? Whether we accept it? Is it Hindi, Marathi, Gujarati, Bengali? These are then Bharatiya, Nagarika, Suraksha, Sanhita. This is Jyotishta language. This is divine language. Let them use this language before worshipping in any temple. Not in the courts. What language is this? We don't accept this captions of these three criminal justice systems. So we don't accept this language. Then Bharatiya, Nagarika, Suraksha. Suraksha means what? Suraksha means defense. What defense is there? Suraksha. Defending what? Therefore, our first and foremost objection is the captions of these three law, which is unacceptable to any, say, each Telangana or Andhra Pradesh. That court language, it is for people of Telangana, people of Andhra Pradesh. It can't be something else. Tamil Nadu High Court, it is people of Tamil Nadu. It's court meant for people of Tamil Nadu. Karnataka courts meant for people of Karnataka. It should be in their language. Therefore, we accepted the common language as English, which has been the administrative language. So, therefore, we advocates should oppose the naming it. It has no sense at all. What is there in Suraksha? What is there in Nyaya? What is there in Sakshya? So, my objection is to that. So then, see, the law is made based on the constitutional provisions. Of course, Indian Penal Code was drafted by Thomas Macaulay in the year 1860. The drafting process was going on even much earlier. Then Indian Evidence Act was drafted by James Stephen in the year 1872. James Stephen. So it's a law drafted by the colonial masters. See, we all know the purpose of enacting the Criminal Procedure Code. Simultaneously, there were Mining Act, there were Forest Act, Land Acquisition Act, various civil acts, that to drain our natural resources, material resources, human resources, the laws were made. And the local people would protest against the loot, draining of natural resources. Therefore, this Indian Penal Code was drafted by Macaulay. He was an agent of East India Company, he was an agent of British, he was an agent of Queen. The purpose was to control the local masses who would protest against Allen rule. That is how Indian Penal Code was drafted, and to suit that convenience, the later part Indian Evidence Act was drafted by James Stephen in the year 1872. So also the Criminal Procedure Code. But in the beginning of 20th century, in the middle of 20th century, see, the world scenario changed. World scenario, then countries become democratic. See, the world over, the concept of John Maynard economic theory was being practiced. Therefore, the good face of capitalism, that is welfare capitalism, welfare mechanism, even the England, America, other East European countries, imperialistic countries were constrained, forced to have a good face, not an ugly dictatorial fascist face. So that is the background behind the drafting of these laws, which was time tested. When Constitution was drafted, see, in consonance with Article 11, Subarticle 1 of Universal Declaration of Human Rights. See, Article 14.3G of International Covenant of Civil and Political Right. International Covenant on Civil and Political Rights. So then Article 6 of European Covenant on Human Rights. So these three covenants of international level is drawn into the Constitution of India. That is the reason why Article 14, equality before law, then Article 19, fundamental rights, Article 21, right to live with human dignity, Article 21. Then Article 20, Class 3 is very, very significant article. Right against self-incrimination, Article 20 subclass 3. Article 22, fair trial. This is based on the international covenant in which India was also a signatory. That is the background. See, what we see in Article 20, Class 3, that was drafted by James Stephen in the year 1872. Section 26, 25, 26 and 27 of the Evidence Act. Statement made before police, after arrest or before arrest, are inadmissible, need not be proved. It has only the dustbin value. Section 27 of the Evidence Act partially lifts the ban imposed under Section 25 and 26. So admissible to the extent of recovery alone, material object. So Pulukuri Kotaya case, there are so many cases. See, even much prior to our Constitution, Section 25 and 26 of the Evidence Act came to be incorporated because the rulers know, the rulers know the police should not be given any incentive. If police is given incentive, if police is given any, ಅವ್ರಿಗೆ ಹೇಳಿಯಪ್ಪ ಶಬ್ದ ಮಾಡಬಾರ್ದಿಲ್ಲ ಅಂದ್ರೆ ಹೊರಗೆ ಕೂತ್ಕೊಳ್ಳೋಕೆ ಹೇಳಿ. See, the incentive is given to the police and they will torture. They will write scripts and say that the accused admitted. The confession has no place in Indian Evidence Act. No place in Indian Evidence Act. See what has happened in the year 1985 during Rajiv Gandhi's regime. They enacted this TADA, Terrorist Activities Prevention Act, Section 15. See, Section 15 of TADA Act, statement, confession statement made before IPS officer is admissible in evidence. That is against the constitutional provision. When Section 15 was challenged before the Supreme Court, Lordship Justice Ramaswamy dissented, though other two senior judges consented for Section 15 of TADA Act, upheld the constitutional validity of Section 15. In the dissent note, Justice Ramaswamy written that this is unconstitutional, either before IPS officer or any officer. Confession is inadmissible in evidence. But the majority bench, what they said, see, this terrorists are a class apart. They are not human, normal citizens. They are a class apart. They are a group apart. So they are not ordinary citizens. It is a special law meant for special circumstance. That was the judgment, Section 15. But TADA had a sunset clause, only for 2 years, but it stretched up to 10 years. 1995, Tada was repelled. Then Vajpayee government came into picture. They want to have a special law. The reason best known to them, we also know. Photo was enacted. Photo. Photo is nothing but replica of Tada. Section 32 of the photo and Section 15 of Tada are same. Statements made before police is admissible in evidence. So it stretched up to 2004. 2004, UPA government came to power. Mr. Chidambaram was the Home Minister. They repelled Pota in the morning and brought ILPA in the evening. During Congress regime, Nyaya Act was enacted, National Investigating Agency Act was enacted, and there was lot of amendments in UAP Act. So Section 43D5 of UAP Act, bail is next to impossible. So there is a proverb, dead body which goes to the cemetery will never come back. Accused in UAP Act go to jail will never come back. So this type of law is UAPA. See, then what happened? Voluntary statement made before police is inadmissible in evidence even under ILPA. The provision of Section 15 and Section 32 of POTA was deleted. ILPA, there is no provision for confessional statement. But states like Maharashtra, Karnataka, Gujarat, they retained the provisions of TADA and POTA in the name of Maharashtra Control of Organized Crime Act. So Karnataka is concerned Karnataka Control of Organized Crime Act. The provision of Section 15 of TADA Act, the provision of Section 32 of POTA Act are retained in Karnataka Control of Organized Crime Act in the Section 19 of KOCA. KOCA means Karnataka Control of Organized Crime Act. So that is just a replica of the draconian TADA and POTA. So voluntary statement, presumption, unfair trial and custody for a period of 180 days, not 90 days. These are all the draconian part of these special laws. Special law and general law. See, IPC is a general law for general citizens from Kashmir to Kanyakumari. But ILPA, TADA, POTA, KOCA, MOCA, these draconian laws are for certain class of people. See, under ILPA, your organization should be banned, invoking the provisions of Section 3. Then constituting of a tribunal and verdict of tribunal under Section 5 of ILPA. Then banning listing of organization in the form of first schedule under Section 35. Under Section 35, 1A and 1B of Unlawful Activities Prevention Act. So then the definition, there is a terrorist organization punishable under Section 39 and terrorist gang punishable under Section 20 of the ILPA Act. See, these are all important. Then how it is related? It is related, therefore I am explaining to this. The arrest procedure is different, search and seizure is different. So these are all draconian law. Now the purpose of this new law, Bharatiya, Nyaya, Sanhita. See, the background of this act is very draconian. See, section 111 of the Bharatiya Nyaya Sanhita. Section 111. You read 111. The entire provisions of Koka, Moka, Tada, Fota are retained in Bharatiya Nyaya Sanhita. This is the justice. Section 111. Any continuing unlawful activity in see all offences. So what I mean to say is the session special law became the general law. Special law became the general law. So it's a draconian for special purpose. Tada was enacted for a limited period. That is, sunset clause is only for 2 years to combat terrorists of Punjab, Khalistan terrorists. That was the purpose of enacting Tada. That is retained in the form of Koka and Moka. Now the special law became the general law. This is not there in Indian Penal Code. Even the Britishers, colonial masters, they never even imagined suspecting the citizens of this country as organized crime syndicate. That is not there during independence struggle. No country in the world except Germany during Hitler regime, except Italy during Mussolini regime, except Idi Amin during, except Uganda during Idi Amin regime, except Franco in Spain, Pinchote in Chile, Marcos in Philippines, Sugarto in Indonesia. They are all the terror. They are all the dictator, fascist, anti-people, inhuman. This law is their law. Therefore, these three law put together, 83% they have taken as it is from the Indian Penal Code, Criminal Procedure Code and Indian Evidence Act. 83%. Not even a word is changed. 83% Macaulay law, 83% James Stephen drafted Indian Evidence Act, adding 17% drawn from Hitler's Germany, Mussolini's Italy. So, de-democratization of Indian judicial system, de-democratization of Indian criminal justice system, inhumanization of Indian criminal judicial system. So what is the purpose of incorporating section 111, organized crime? This is the offshoot of Tada and Photo Act, which everyone should object. You and me are also an organized crime syndicate. Any human being, any citizen in India will be an organized crime syndicate. And the punishment is very, very severe. Then you take section 113 of Bharatiya Nyaya Sanhita. Section 113, Terrorist Act. It is captioned as Terrorist Act. You read section 15. You read section 16 of Unlawful Activities Prevention Act. See, that is incorporated as 113 of the Bharatiya Nyaya Sanhita. This is the Nyaya. This is the justice. So, from people from Kashmir to Kanyakumari are branded as terrorists. Anybody can be booked under this act, Terrorist Act. Same language, construction of section, construction of words. Construction of language, everything line by line, comma, full stop, everything as it is taken from section 15 of the Unlawful Activities Prevention Act. Punishment provision is section 16 of the Unlawful Activities Prevention Act, 15 and 16. There what happens to invoke section 15 and 16, there must be a terrorist act committed by a terrorist organization or terrorist gang as defined under section 2 MLM. Terrorist gang, terrorist organization, terrorist activity. That is a special law for special class of people. See, then 35(1)(b) of UAP Act says the government should proscribe an organization, ban an organization. Before banning, there must be a notification. Then there must be a judicial proceedings before the tribunal chaired by the sitting judge of any high court in India. Then there must be a panel of advocates on behalf of the state and panel of advocates on behalf of the organization, then volumes of evidence. It's a laborious process to ban an organization. In India already 43 organizations are banned. It's only Maoist organization, secessionist organization, Islamic organization. Only these three type of organizations are banned. I'm not going deep into that. And member of those organizations alone can be prosecuted under Unlawful Activities Prevention Act. Only in respect of those sections, National Investigating Agency can investigate, and it must be tried before a National Investigating Agency court called as Nyaya court. Now, all of a sudden, by a stroke of the authority of Mr. Shah, so all over India, from people from Kashmir to Kanyakumari can be tried as a terrorist, whether it is acceptable. Section 13 Terrorist Act. Advocate who committed some offence or fabricated in some case can be booked under Terrorist Act, no bail, death sentence. So these two provisions, 111 and 113, these two special provisions are incorporated in the name of Bharatiya, Nyaya, Sanhita. So nobody can escape. There is no necessity. Now there is no necessity for the state to book citizens under this provision only with regard to the proscribed so-called terrorist organization. So anyone from Kashmir to Kanyakumari can be booked under section 113. So no bail provisions. 111 no bail, 113 no bail. This is one aspect of it. Then you come to section 147, chapter 7 of Bharatiya, Nyaya, Sanhita. Chapter 7, section 147 to 158. See, now the present ruling dispensation claims that they have repelled 124A of the Indian Penal Code. It is bogus concept. See, more draconian 147, 148, 149, 150, 151, 152. These are all very draconian section. Integrity. sovereignty, integrity, territorial integrity, secessionism, successionism, all that is incorporated here. Earlier it was from 120 to 130. Now it became 147 to 159. So this any citizen who wanted the constitutional provisions to be implemented, wanted lands to tribes, lands to Dalits, land to the tiller who tills it, wages to the laborers, equitable distribution of material resources, all can be booked under chapter 7, section 147 to 158. So this now again in this entire concept of decolonization of the existing Indian Penal Code. See, decriminalization and criminalization. Criminalization of Dalits, Shudras, minorities, minority Muslims, minority Dalit, minority Christians, minority Sikh, Buddhist, Parsis. Criminalization, A plus, L plus citizens, vulnerable, marginalized section of the society. So this is against 82% of Indian population. This is pro 3% of Indian population. So that serious is the case. Then you read this Bharatiya, Nyaya, Sanhita. Land grabbers are exempted. Mineral rooters are exempted. Forest looters are exempted. Environmental destructionists are exempted. They are not offenders here. Then human resource looters, non-payment of minimum wages, non-payment of bonus, leave, PF, ESI, job security, wage security, social security, unprotected workers. These looters are not accused in Bharatiya, Nyaya, Sanhita. Under this act, you can't book Ambani, you can't book Adani, you can't book Tata, Birla, Dalmia, Singhania. All the corporate looters are saved in Bharatiya, Nyaya, Sanhita. Selling of airport, selling of seaport, selling of aircraft, selling of nationalized industries, selling of public sector, lynching of election commission, lynching of planning commission, lynching of all commissions, commissionerate, all existing system. Nothing is an offense in this Bharatiya, Nyaya, Sanhita. So business class is protected. In the sense, Vaishyas are protected. Powerful community, Brahmins are protected, Kshatriyas are protected. But targeted Dalits, minorities, Adivasis, forest looters are not punishable under this act. Therefore, it is a discriminatory act. I will leave at this. As far as the IPC is concerned, there are so many other aspects. So, time constraint. Then you come to the Criminal Procedure Code. Bharatiya, Nagarika, Suraksha, Sanhita. See, this act, power is bestowed upon the police to use force at the time of arrest. See, arrest how made? 43. May use all means necessary to effect arrest. So, while arresting the person, the law bestows power upon the police to commit torture on the targeted communities, targeted accused persons, targeted offenders under section 111, targeted offenders under section 113, targeted offenders under section 147 to 158. These provisions are meant targeting marginalized and vulnerable sections of the society. Then search and seizure liberalized. Handcuffing is permitted. The practicing advocates know that the apex court judgment set ratio that handcuffing is inadmissible. Unless permission is taken from the court, the accused cannot be handcuffed. But this Bharatiya, Nagarika, Suraksha, Sanhita, handcuffing and torture is permissible. So torture and handcuffing, the forward community, higher caste community is exempted.
Incoming voice call from +91.
The caste and class. The ruling class and the ruling caste are exempted from handcuffing and torture. So this Bharatiya, Nagarik, Suraksha, Sanhita provides forward to the investigating agency, whether it is a local police or CBCID or Grey Ones or NIA, CBI, all law enforcement agencies bestowed with the power of torture and handcuffing. That is also not permissible. That is also not permissible. So this has to go. Then see disbursement. Chapter 11. Chapter 11. Dispersal of assembly by use of all force. So any assembly can be dispersed use of force. Section 149. Armed forces can be used. It is something like Armed Forces Special Powers Act. Jammu and Kashmir Armed Forces Special Power Act. So now the special powers bestowed upon Armed Forces Special Powers Act, especially 9 sister states, northeast states, and Kashmir. See here, section 148, 149, 150. These 3 provisions gives extraordinary power to the police. Extraordinary power to the police or any armed forces to use arms. See, this is another. Then section 161 subsection 2 of the Criminal Procedure Code provides statement recorded by the police is not to be signed, that is inadmissible in evidence. But section 181, 189 statement made before the police is admissible in evidence. So 182 is also in violation of section 161 subsection 2 of Criminal Procedure Code. See, then most significant aspect in this Bharatiya, Nagarik, Suraksha, Sanhita is section 187 and 188. This is the very dangerous provision. See, 167 subsection 2 proviso A. First 15 days could be such custody. It could be police custody or it could be judicial custody. Necessarily, after culmination of first 15 days, it should be judicial custody. See, taking an accused to police custody is a very serious issue. Police station, we all know there is no provision for bed, restroom. It's only lockup. The accused should be within 5x5 room lockup. No bed, no pillow, no water, no fan, no facility. Spending one day in the police, see, people may spend 1 month or 1 year in the prison wherein they were given some freedom to move. But in the lockup, it is so congested in the lockup. This section 187, it can be at a stretch 40 days. Any time they can take. See, any time they can take into police custody. First 15 days, they may take 5 days. Leave it for 1 month, then may take for another 5 days. Then 5 days. The accused consent should be in constant fear. The purpose of enacting this new provision, section 187 and 188, is to provide to police authorities to manufacture evidence, to fabricate evidence. Step by step they can manufacture evidence. Sound వస్తా ఉంది చూడండి. Sound is disturbing. Okay. See, 187, 188 of Bharatiya, Nagarika, Suraksha, Sanhita. See, up to 40 days. If the offence is less than 10 years, if the offence punishable is more than 10 years, over a period of 90 days, 60 days, whenever police wanted the custody of an accused, they can take as per their whims and fancies. Then they may be asked to this confession statement can be manipulated. Recoveries may be planted. Blood can be drawn. Human hair can be drawn. That can be subjected to DNA. So DNA, everything can be manipulated. Digital evidence can be manipulated. Voice can be manipulated. If this 187, 188 is permissible, then there will be mockery of justice. The process is inhuman, which is not acceptable by the Indian Constitution. Constitution of India don't accept this. International covenants of civil and political rights don't accept this. European covenants of human rights don't accept this. Universal Declaration of Human Rights don't accept this. This 187, 188 are draconian. This is not up to international democratic standard. Such a serious thing is there. Therefore, 167 subsection 2 proviso A, time tested. It is a testament over a period of 150 years. Now rebooting in the name of decolonization, bringing a fascist evidence act is unacceptable. So here I will leave this Bharatiya, Nagarika, Suraksha, Sanhita. Let us take this Bharatiya, Sakshya, Adhiniyam. So Evidence Act is very, very significant act. The defense mechanism stands on Evidence Act. If Evidence Act is inhuman, not democratic, if Evidence Act is unfair, It is not as per Article 20 is class 3. If it is not as per Article 22, 23 of Constitution of India, then we can't claim that India is a democratic state which gives defense mechanism for the lawyers to defend their clients, because we don't believe in police investigation system. It's all fabricated system. An innocent can be booked, a criminal can be left out. Now it became a Gunda Raj, it became a police Raj. See, in the beginning of my talk, I said Article 20, Class 3, 22, then 25, 26 of the Evidence Act. So this gives no incentive to the police to extract confession in the name of confession by the accused. That's inadmissible. Now you please read Section 22. It is very, very dangerous. Section 22. 22 provided, Proviso A and Proviso B, provided further. Provided that if the confession is made after the impression caused by any such inducement, threat, coercion or promise as in the opinion of the court been fully removed, it is relevant. So this is dangerous, provided. That means it gives goodbye, go by to Section 25, 26 of the Evidence Act. So any confession made before even Sub-Inspector of Police is admissible in evidence. What the court should see to it is that if the confession is made after the impression caused by any such inducement, threat, coercion or promise as in the opinion of the court been fully removed, it is relevant. So confession statement recorded by the investigating agency right from Sub-Inspector of Police to Inspector or DSP or a special cell like CBCID, Q branch, NIA is admissible in evidence. This is more serious than Section 15 of Tada Act, Section 22 of Pota Act, 32 of Pota Act, Section 19 of Karnataka Control of Organized Crime Act. So confession made before the Sub-Inspector of Police is admissible in evidence. And we know how the police inspectors behave. They are just stooges of the political party which is in power. Any police officer can be maintained by a MLA or any ruling dispensation. And confession statement recorded by the Sub-Inspector of Police is admissible in evidence. It completely power is bestowed upon the trial court to delete, remove any threat or inducement. So the court power is also melted away. So who is a witness against accused? Himself is the witness against himself. Though no evidence is forthcoming, the police can manufacture such evidence. Then provided further that if such a confession is otherwise relevant, it does not become irrelevant merely because it was made under a promise of secrecy or in consequence of a deception practiced on the accused person for the purpose of obtaining it, or when he was drunk, or because it was made in answer to questions which he need not have answered, whatever may have been in the form of those questions, or because he was not warned that he was not bound to make such confession and that evidence of it might be given against him. If the confession is otherwise relevant, inducement, threat, coercion, intoxicated, the power is given on the court. Therefore, one should understand, if section 22 proviso A and B are not deleted, if you don't protest against these two draconian provision, then the defense is doomed. It will affect the marginalized A plus, L plus, vulnerable section of the society who are nothing other than Adivasis, Dalits, minorities, and workers, farmers. The farmers who want to protect their land will be branded as terrorists. Union which is organized for wage may be branded as organized crime syndicate. This is how Hitler declared unions as crime syndicate in Germany. So, voluntary statement made before sub-inspector of police is admissible in evidence. We do not know how the honorable courts will set at rest these grey areas left by the drafters of this constitution. Then I will leave it at that. Then section 115, presumption as to certain offences. 115 of the Bharatiya Sakshya Adhiniyam, where a person is accused of having committed any offence specified in subsection 2, declared as disturbed area. Also, subsection 2, 115 subsection 2, the offence referred to in subsection 1 are of following, namely, an offence under section 147, section 148, 149 or section 150 of Bharatiya Nyaya Sanhita, criminal conspiracy or attempt to commit abatement on offence under section 149 or section 150 of the Bharatiya Nyaya Sanhita. So, presumption, proof beyond reasonable doubt is gone. As far as these sections are concerned, prove beyond reasonable doubt, prove beyond shadow of doubt, presume the accused as innocent till the guilt is proved. Moment the case is registered, he is guilty. Burden is on the accused to prove that he is not guilty. Reverse burden. Diverse burden is meant to handle separate class of persons. Therefore, these special acts, but this is made incorporated into the general law. So, section 115 of the Evidence Act, Bharatiya Sakshya Adhiniyam, is inhuman. It will dent our practice. It will affect our clients. There is no defense mechanism. Once charges are framed, it is very difficult for us to get benefits. See, those lawyers who practice in Nyaya court finds it very difficult to get an acquittal. Acquittal is next to impossible before Nyaya court, because UAP Act and Nyaya Act makes mockery of criminal judicial system, makes mockery of the trial. See, no interim order can be challenged before the higher courts, invoking section 397 or section 482 or article 226 of the Constitution of India. So if that happens to the general law, if presumption, defense burden, then it is very difficult. Then see this digital evidence. This digital evidence, see, cut and paste method. Any digital evidence can be edited. There are Adobe device, there are Write Blocker, there are so many devices. It can be edited by cut and paste method. See, by every evidence is recorded in an interface. Interface may be camera. Camera contains chip or memory card. Then the laptop, desktop contains hard disk. The servers of huge servers maintained in the mobile companies, service providers, they have huge servers. it contains the hard disk, then it has to be retrieved from one format to other format. Normally it should be the text format. What we see in the court is Excel format. While converting text format to Excel format, any number can be added, anything can be edited. So chip, memory card, hard disk, DVR, NVR, chip, memory card, these are all storage devices. When it is retrieved or burnt into CD, DVD, pen drive, printouts, these are all computer printouts. It should be subjected to hashing process. See, when a CD is made or a pen drive made, it generates ILPA numerical values. ILPA numerical values. It's a digital number. It's called as hashing process, which is also called as authentication process. Then we are, as a defense lawyer, presently we are entitled for the mirror image or clone image of the hard disk, with which we can ascertain whether the computer output is manipulated, inserted, edited by cut and paste method. See, all these things are there in the present penal code, Indian Evidence Act, section 65B, subsection 2, subsection 4, proviso C, then 45A of the Evidence Act, hashing expert opinion. Then it should be in consonance with section 79A of the Information Technology Act. Now, by amending these provisions, inserting in the form of section 63 of Bharatiya, Sakshya, Adhiniyam. See, you see, Absal Guru was convicted based on the digital evidence. There in the year 2005, Honorable Supreme Court said, digital evidence is primary evidence, it is not secondary evidence. Conviction can be held. Then lawyers, we know, Anwar's case, 2014, Supreme Court, 3-bench decision, held that, see, it is susceptible to editing, cut and paste method. Anything can be inserted. Therefore, the digital evidence is secondary evidence. It can't be accepted without a 65B certificate. Further, it has to be subjected to hashing process, authentication process. ILPA numerical value need to be generated, and it has to be matched with the hard disk to that of the computer output. Computer output is the pen drive, DVD, CD, printed format. So this is the protection. Now deepfake device is in the market. Anything can be manipulated. Deepfake, Pegasus hardware. So something can be inserted into my laptop or my mobile, which has a website, internet connection. The proof should be in the form of internet protocol. To book a person, there must be connectivity. That is again a digital number. There are static internet protocol number, dynamic internet protocol IP address. So pool of IP addresses. It keep on changes wherever there are Wi-Fi. And every day millions of Wi-Fi address are distributed to different users. These guarantees, see Anwar's case, then comes Safi case, then Hiramat case, then comes Pandit Rao's case, 2022 Supreme Court, Pandit Rao case. Then 2023, Tamil Nadu case, Subramaniam versus State of Tamil Nadu, their lordship in the Supreme Court reiterated Anwar's case. Then the latest by Nazir's case, Nazir versus State of Karnataka, the latest judgment on that point. So this section 63 of Bharatiya Sakshya Adhiniyam gives complete goodbye either to digital evidence, digital documents or secondary evidence. Now Bharatiya Sakshya Sanhita makes digital evidence as the primary evidence. If it became primary evidence, it is possible for the law enforcement agency to manipulate. It is possible. There are various applications, there are various devices which can be used to insertion. Nobody is safe. You all know in Bhima Koregan's case, Pegasus was used to manipulate that they made a conspiracy against some personality and they have been languishing in jail, incarceration for several years because of Pegasus, now deep fake technology. But that is where the time and again, right from 2014 to 2023, time and again, the Honorable Apex Court set ratio, what are all the authentication process. It is not admissible in evidence by way of authentication process. So therefore, these provisions, it takes away the defense mechanism. Then who should enact a law? There is an objection to that also. You see, Macaulay, Thomas Macaulay and James Stephen, they drafted these laws. As a committee representing the colonial masters, British East India Company, British, but after independence, India has Law Commission. Law Commission has been the authority to amend law. We have no objection. Laws should be amended. But who should do that? Before doing that, the stakeholders should be consulted. Whether a stakeholder is consulted, whether Law Commission is taken into consideration, whether people of India is taken into consideration, whether Lok Sabha, Rajya Sabha are taken into consideration, whether advocates associations are taken into consideration, whether bar councils are taken into consideration, by and large, the stakeholders are the lawyers, the stakeholders are the people. Whether they are taken into consideration in revamping, replacing major criminal justice system by way of these three laws. See, who are the members now? 2018, there was an attempt. 2020, a 5-member committee was constituted. Who are all these 5-member committee? Vice Chancellor, National Law University, Dr. Ranbir Singh. Who is he? He is a Vice Chancellor. Then Registrar of NLU by name Bajpai, Registrar. And a Professor Dr. Balraj. A Professor, a Registrar, a Vice Chancellor of National Law University are the main drafting committee members of these three Sanhitas. In addition to that, a senior advocate who is from RSS, Mahesh Jethmalani, son of Ram Jethmalani, 4th member. Then a retired Sessions Court Judge Tareja. These are all the 5 personalities who indeed represent the ambition of Nagpur. This is a Nagpur drafted law because all the 5 members are the supporters of Nagpur. Criminalization and decriminalization. Criminalization of the people by and large. Decriminalization of mineral looters, mining looters, aircraft looters, railway looters, seaport, airport looters, human resource looters. Already 44 labor laws are consigned as 4 codes, pushing the Indian working class 200 years back, denying job security, wage security, and social security. If they fight these draconian laws, they will be branded as terrorists, they will be branded as organized crime syndicate. So this law is made targeting Adivasis and their organization. This law is made Dalits and their organization. This law is made targeting Indian working class and their organization. This law is made targeting farmers and their organization. This law is made minorities and their organization. This law is made targeting the protector of Indian Constitution. This law is made to protect our protectors of natural resources. This law is made to attack the protectors of human rights, to attack the protectors of the national rights. This law is unconstitutional. Therefore, at the outset, there are a lot of reforms in various laws. Mining laws are amended to loot mineral resources, dispossessing tribal communities. Acts are made to loot the lands. Acts are made to drain every resources available. Acts are made, human trafficking. Acts are made to send laborers at a cheap rate. Indian labor is the cheapest labor in the world. They can't protest. Therefore, in the economic interest of corporate, it is corporatization of Indian criminal judicial system. This is sovereignization of Indian criminal judicial system. This is unconstitutional, anti-national, inhuman. At the outset, it is anti, which we don't accept. The lawyers should raise their voice against these inhuman acts brought down by the ruling dispensation, which has a different connotation of Indian system, and they are making all the attempt to redraft the constitution itself. Many constitutional provisions are just violated in framing different laws. Thank you. My time is 1 hour. I think I have taken 1 hour and 15 minutes. Thank you.